Hi, this is Paul Padda of Paul Padda Law. Today I want to talk to you about medical malpractice in Nevada. One of the questions I get asked the most by clients is, what is considered medical malpractice? So in Nevada, the definition of medical malpractice is when a healthcare provider falls below what is considered the standard of care. And of course, the standard of care, as that term is commonly used, is itself subject to further definition based upon the specific facts of a case and the particular medical specialty involved. So in every medical malpractice case, the standard of care is often determined based upon national standards and through the testimony of expert witnesses. Now, what does that really mean? What that means is that during the case, in order to prevail in a medical malpractice case, you have to prove that the standard of care was breached. That means that the doctor fell below what was expected of him or her as far as the standard of care goes. The standard of care could apply also to a hospital and various other types of medical professionals. But essentially, in understanding the term standard of care and knowing what is considered medical malpractice, what you need to know is that it is basically conduct that falls below what is expected, normally expected of a doctor or a hospital or some other medical provider in that particular specialty. In other words, they fell below the standard of care. They fell below what is normally expected of them. Another question we often get here at the law firm is, who can be liable for medical malpractice? Is it just doctors and hospitals? Well, in Nevada, of course, physicians and hospitals are certainly liable if they commit medical malpractice. However, medical malpractice laws in Nevada apply to a whole bunch of other type of specialists. People like dentists, psychologists, nurses, physical therapists, chiropractors, physician's assistants, and many other types of healthcare practitioners. So medical malpractice is not just limited to physicians and hospitals, although I would say, having a lot of experience in this area of law, that the vast majority of cases do involve hospitals and physicians. Many folks who are, exploring the possibility of whether they have a medical malpractice case will often ask us here at the law firm, what do I have to prove to win a medical malpractice case in Nevada? If I've been the victim of medical malpractice in Las Vegas, what am I going to have to prove? The first thing that you have to prove in order to prevail in a medical malpractice case is that there was number one, a patient-provider relationship. What that means is that you were a patient and there was a healthcare provider who had a relationship with you because they were treating you. So for example, let's say you were in a hospital and you overheard a doctor giving someone else bad advice. You couldn't sue that doctor for giving bad advice because you are not their patient. So there has to be a patient-provider relationship. That's number one. The second thing you have to prove is that there was a breach of the standard of care. Remember, we talked about standard of care earlier, and that's what that is. Basically, it means somebody fell below the expected standards required in that particular situation. So you have to prove that you had a doctor-patient relationship and the doctor or the hospital or some other healthcare provider, whichever it might be, breached the standard of care. The third thing you would have to prove is that there was a breach. The breach of the standard of care was the proximate cause. What that means is basically that it was a significant factor in you experiencing medical malpractice. So let's say the breach of the standard of care was a very remote cause, or it was remotely connected to the bad thing that happened to you. You would probably not be able to prevail in that case because you wouldn't be able to show proximate cause. Think of proximate cause this way. It means that basically, but for the malpractice, you would not have experienced the injury that you did. Let me give you an example. Let's say somebody goes in for a surgery, and let's say the doctor leaves a sponge inside the person, and the person experiences all kinds of problems as a result. Well, clearly, leaving the sponge in there was the proximate cause of the injury that was a result of that surgery. So the person would then be able to show that, look, but for this sponge, I wouldn't have experienced all these problems. That is one of the most important and essential elements of any medical malpractice case. The vast majority of cases that are lost in medical malpractice are lost based on this concept of proximate cause. Finally, the fourth thing you have to prove is damages. If you don't have damages, you don't have a case, right? So even if something terrible happened to you, unless you could show that you have experienced some type of damage as a result of that, you wouldn't be able to bring a case. Damages and proximate cause are the two most important factors. But basically, those are the four things you have to prove in a medical malpractice case. Let's recap those. 1, patient-provider relationship. 2, a breach of the standard of care. And 3, the breach was the proximate cause. And finally, 4, that you have sustained damages. So a question we often get also is, how long does a patient have to file a claim for medical malpractice in Nevada? Now, the answer to that question changed actually in 2024, but it used to be that you only had a year. The law was changed, and the law was changed specifically on October 1st, 2023, to be precise. That's when the state legislature in Nevada amended the medical malpractice laws. So as a result, now, if you're a patient, you have 2 years, that's 2 years within which to file a lawsuit in Nevada alleging medical malpractice. Now, there's some exceptions. For example, if you can show that you didn't have reason to know you were the victim of malpractice, nor should you have known because of some other reason, you might have up to 3 years to file a suit. But it's important to remember, that's the exception, not the rule. In the vast majority of cases, you're going to have 2 years to file a lawsuit. So if you experience medical malpractice, if something happens to you and you suspect that you were the victim of medical malpractice, what you need to know is that you have 2 years from the date of that incident to bring a lawsuit. How much is a medical malpractice case worth? Now, this is a question that I think a lot of people ask when they're contemplating bringing a lawsuit. They want to know, is it worth it? What could I recover? What is my case worth? And I hate to give a lawyerly response to this kind of question, but it really, unfortunately, it really does depend. It depends on the situation. No two cases are alike. No two situations are alike. Let's think about it for a minute. It's going to all come down to the severity of the malpractice and, most importantly, the severity of injuries. If you have a lot of injuries, let's say you experience medical malpractice and as a result you're not able to walk anymore, my goodness, that would require all kinds of care going forward in the future. It would require you possibly to even change jobs because maybe you're not able to be mobile as the way you were before. There are a lot of things that could get affected because of that. So your injuries are going to be more severe. As a result, your damages are going to be more severe. So again, it all comes down to the extent of the injuries. Now, in medical malpractice cases, there's 2 types of damages you can recover. One are economic damages and the other are non-economic damages. In the case of economic damages, those are things like medical bills, care you're going to need going into the future, things that are actually hard costs. Non-economic damages are things like pain and suffering. I mean, it's not always just about the money that you're spending as a result of being damaged or injured. It's also the pain and suffering you're experiencing. And so if you bring a medical malpractice case, you are also entitled to recover for not only the pain and suffering you've experienced immediately following the incident, but also well into the future. So what should you be looking for when you're considering hiring a medical malpractice lawyer in Nevada, or specifically even Las Vegas? What are the factors that you should consider when you're looking for a medical malpractice attorney who can represent you or your family or a loved one in getting justice, in basically going to court and getting a good recovery based upon what's happened to you? I think there's 3 things to really focus on. Number 1 is the experience of that attorney. Has that attorney tried, litigated cases of medical malpractice? Do they have the experience that it takes to win cases of that kind? Medical malpractice cases are often extremely complex. Think about it. You're dealing with suing a doctor, so now you have to get into talking about whether the medicine was, the medical judgment was proper. To do that, you have to have expert witnesses. It takes a lot of experience, and it takes the right kind of experience in order to win those cases. The second thing you should look for in an attorney is, does that attorney have the financial resources to go the distance? What do I mean by that? What I mean is that These are not cheap cases to try. These are not inexpensive cases to work up. They require hiring the best experts. The medical experts can charge many, many thousands of dollars. I've had cases where we've spent almost $500,000 trying to get the client a result, and because of that, we were able to get a phenomenal result. But again, like I said, you have to have an attorney who has the financial resources to go the distance. And then finally, a third factor I would look at if I was in the position of trying to hire a medical malpractice attorney is I would look at that attorney's personality. Do they jibe with me? Do they convey a sense of compassion? Do they empathize with my situation? You know, at the end of the day, at least here at Paul Padda Law, when we take on a case, we take on a case with the expectation that, number one, we're going to go the distance. We're going to try that case in court, and we're going to do everything we can to win that case. So therefore, you know, we have to be able to tell that client's story with conviction. And this comes down to having a good personal relationship with the client. As an attorney, if you cannot relate to your client, you're never going to be able to effectively tell that person's story to a jury. And so personality is very important. At Paul Padda Law, we've handled lots of medical malpractice cases, and we've handled them with great success. You know, we recently settled a case while we were actually still picking a jury, because when the hospital realized they better settle or they could face a multi-million-dollar verdict, they stepped up and did what was right in the middle of the trial. But guess what? That didn't just happen by accident. That happened because we spent a lot of time preparing when it comes to winning that case, and that's what we do in every case. If you're looking for a good medical malpractice attorney, if you are looking to explore whether you have a medical malpractice case, call us today. Call us at 702-707-3000. If you're looking for a lawyer in Las Vegas or anywhere who can handle a case in Nevada of medical malpractice, call us and let us help get you justice.